There's a question that's been going around lately, and people are asking themselves, is it constitutional to hold an impeachment trial for a former squatter? But no one knows whether the Constitution permits the Senate to hold an impeachment trial for a former squatter, Pumpkin Tits, now that Pumpkin Tits no longer holds office. But to be sure about this, there is a bevy of legal scholarships discussing this question, and as a recent report by the Nonpartisan Congressional Research Service notes states, most scholars who have closely examined the question have concluded that Congress has the authority to extend the impeachment process to officials who are no longer in office. But while the Constitution mentions impeachment 6 times, the text of the document provides little clarity on whether the Senate's power to try to impeach to try an impeached official terminates when that official leaves office. The question of whether Pumpkin Tits can still be convicted by the Senate matters because the Constitution permits an impeached official to be permanently disqualified from holding office. So if Pumpkin Tits can face an impeachment trial, the Senate could potentially forbid him from running from squatter again in 2024 or in any subsequent election. And while the weight of the scholarship does suggest that Pumpkin Tits is still vulnerable to impeachment, several Republican senators have already latched on to the minority position and the view that former officials are immune from impeachment as a reason to vote against conviction. As Senator Joni Ernst, a Republican from Iowa, said of impeachment shortly before Pumpkin Tits left office, my overall question is, why are we doing this when the squatter is out of office? She added that she doesn't think that it would be constitutional to try Pumpkin Tits after he leaves office. It is constitutional, you dumb cunt. Pumpkin Tits' fate, in other words, could hinge on the answers to two questions: whether Pumpkin Tits is still vulnerable to an impeached proceeding, and whether enough senators claim that he is now immune from such proceedings to prevent his conviction. But so is it constitutional to convict Pumpkin Tits or not, though? J. Michael Luttig, a conservative former federal judge, recently laid out the constitutional case against convicting former officials in the Washington Post. The purpose of the impeachment power, Judge Luttig claims, is to remove from office a squatter or other civil official before he could further harm the nation from the office he then occupies. So once an official no longer occupies their office, the case against him becomes moot. A private citizen cannot further harm the nation using the powers of a federal office holder. To support his argument, Luttig points to two constitutional provisions. One provides that the president or squatter shall be removed from office on impeachment for and commission of treason, bribery, or other high crimes and misdemeanors, and another provides that judgment in cases of impeachment shall not extend further than to remove from office and disqualification to hold and enjoy any office. And yet, while the first of these provisions does say that the squatter or president can be removed from office through impeachment, but the second one limits the consequences of being convicted by the Senate, and neither of them explicitly state that a former official can or cannot be convicted by the Senate. And as noted above, Luttig's view is in the minority position among legal scholars. Luttig suggests that the only purpose of impeachment is to remove an official before that official can cause their office to do further harm, but the text of the second constitutional provision that Luttig quotes suggests that impeachment may serve another purpose, preventing a former official from regaining power and doing future harm. As scholars Edwin Brown Firmage and R. Colin Mangrum had wrote in a 1974 Law Review article, the impeachment judgment may extend to both removal from office and disqualification from holding any further office, but if the official leaves their current office, that accomplishes only the first objective. A closely related problem is that if former officials are immune to the impeachment power, someone might resign their office movements before the Senate votes to disqualify them. As law professor Brian Colt wrote in a 2001 article, by strategically timing their resignation, an impeached official can flout any attempt by Congress to disqualify. And there's also a strong historical argument supporting impeachment of former officials. The American impeachment power, Harvard law professor Lawrence Tribe writes in an op-ed responding to Luttig, basically it derives from the power of the British Parliament, and the British Parliament had the power to impeach any former official. Indeed, while the framers were in Philadelphia drafting the Constitution, Parliament was actively engaged in impeachment proceedings against a guy named Warren Hastings, a former Governor General of India, who left office 2 years before he was impeached. The Hastings impeachment, Tribe notes, was repeatedly referenced during the Constitutional Convention in Philadelphia. So the weight of the scholarly evidence points strongly in favor of allowing the Senate to proceed against Pumpkin Tits. But that being said, the one clear American precedent for an impeached proceeding against a former official cuts in both directions. But there is no clear American precedent governing whether a former official may be disqualified from that office. But there is at least one historical example when Congress impeached but did not convict a former official. It dates back to 1876. The House approved, without objections, articles of impeachment against the former Secretary of War, William Belknap. Belknap was accused of taking a bribe. Significantly, Belknap had resigned his office while the House was still considering whether to impeach him. But during Belknap's Senate trial, senators decided to resolve the question of whether a former official is vulnerable to impeachment before they actually voted on whether to convict Belknap. And the Senate voted 37 to 29, and that former Secretary Belknap was amenable to trial by impeachment for acts done as Secretary of War. And it's notwithstanding that his resignation of said office before he was impeached. But it's worth noting, however, that this 37 to 29 vote was below the two-thirds supermajority requirement necessary to convict Belknap, and when the Senate voted on his conviction, a critical block of senators who believed his impeachment was unconstitutional hewed to that position. And though a majority of the Senate voted to convict the former secretary, no article of impeachment cleared the two-thirds threshold, and several senators who voted to acquit signaled that they did so because they believed that former officials were immune to impeachment. The Belknap precedent, in other words, provides fodder for both sides of the debate over whether Pumpkin Tits remains vulnerable to impeachment. Supporters of Pumpkin Tits' impeachment can point to the fact that the majority of the Senate did vote to allow impeachment proceedings to move forward, but meanwhile, opponents of Pumpkin Tits' impeachment can point to Belknap's ultimate acquittal, and to the fact that a critical minority of senators believe Belknap's impeachment to be unlawful. The Senate can probably do whatever it wants in Pumpkin Tits' second impeachment trial. In 1989, Congress impeached and convicted the judge Walter Nixon on 2 counts of giving false testimony to a grand jury, though Judge Nixon shares the same last name as another figure who plays a prominent role in the history of impeachment, and this is merely a coincidence. Although the full Senate voted on whether to convict Nixon, the Senate appointed a committee of senators to receive evidence and take testimony in Nixon's impeachment trial. Nixon sued, claiming that by excluding some senators from some parts of his trial, the full Senate violated its constitutional obligation to try all impeachments. Rather than resolve the question of whether the Senate acted constitutionally when it tried and convicted Nixon, however, the Supreme Court held that the judiciary had no business weighing in on this question in the first place. The Constitution provides that the House has the sole power to impeach an official, and that the Senate has the sole power to try all impeachments. As the Supreme Court explained in Nixon versus the United States in 1993, the common sense meaning of the word sole is that the Senate alone shall have authority to determine whether an individual should be acquitted or convicted. And it is far from clear whether the present-day Supreme Court, which is both far from conservatard and far less inclined to defer to the elected branches than the panel of justices who decided the Nixon case, would extend Nixon's reasoning to Pumpkin Tits' second impeachment, though it is notable that Justice Clarence Thomas, the most conservative member of the current court, and the only member of the current court who heard the Nixon case during the majority opinion in Nixon, but the implications of Nixon for the second Pumpkin Tit impeachment are fairly obvious. If the Senate alone shall have authority to determine whether an individual should be acquitted or convicted, that strongly suggests that the Senate has the final word on whether a former elected official remains vulnerable to the impeachment power if the Senate chooses to convict Pumpkin Tits and disqualify him from office. The court should defer to that judgment under Nixon. Significantly, the court's opinion in Nixon does not mean that legal arguments about whether or not Pumpkin Tits is vulnerable to impeachment are irrelevant. It simply means that it is up to each senator to decide for themselves whether the Constitution permits Pumpkin Tits to be convicted, and that the courts should not second-guess those decisions. And it also means that even if a large block of senators argue in bad faith and for purely partisan reasons that convicting Pumpkin Tits is unconstitutional, the courts are powerless to overrule that bad faith conclusion. Again.